Ottoman property tenure and administration reform is widely considered one of the most significant developments of the Tanzimat period. Its legacy is evident in the land laws of Israel and Palestine today. This decades-long, multifaceted reform was announced in broad terms in 1839 at Gurhane, and by design was implemented gradually across the empire, beginning in Anatolia in the 1840s. Property tenure and administration reform is generally subsumed in the literature under the title of the 1858 Arazi Kanunamesi, the Land Code. Today I want to explain why this is an inadequate misnomer. In 1875, 1 year after the promulgation of an Ottoman law announcing the issuance of tapu title deeds for private properties, or mulk, a small governmental survey team traveled across the villages of the sub-district of Hebron and systematically registered close to 500,000 dunams of rural properties, both private and state-owned, that is miri, as well as villages' non-taxable properties. It is likely but uncertain that this was not the first time such a survey was conducted in the district. However, this survey is the first and only one of which we have record. In this presentation, I will make use of the record of this survey and evidence from late Ottoman Sharia court records to analyze the implementation of Ottoman property tenure reforms in the Hebron district from the bottom up. There is a very significant and broadly influential literature on Ottoman land reform in Palestine from a legalist perspective. There's been insightful work on the post-Ottoman situation of ownership and on the reinterpretation and application of Ottoman land laws during the Mandate and in Israel. In contrast, the praxis of Ottoman property tenure reforms remains uninvestigated and unknown. The hegemonic narrative deems Ottoman land reforms a failure. The parameters of this narrative are well known. The Fellahin feared that additional taxes and military conscription would result from land registration. They could not understand the significance of a title deed for future security of tenure. Thus, they evaded property reforms en masse, allowing notables and elites to instead register their lands and obtain the tapu title deed, effectively obtaining their ownership. This was an error that would come to haunt them in the Mandate period when these new, large landowners sold lands to the Zionists, who brought to an end the sharecropping tendency of Fellahin on their own lands, a status they had assumed as a consequence of evading land titling reforms. However, an examination of the historiography of this narrative over the past century does not uncover the use of evidential substantiation from the Ottoman period to support it. Rather, the narrative is teleology. I suggest that we have been misreading reform. It may be that our understanding of Ottoman property tenure and administration reforms is still overly influenced by the modernization paradigm, which helps to explain the concerted focus on cadastral surveys and titling in our research. My initial investigation of the implementation of reform in Hebron points to the conclusion that we have overemphasized the importance of titling, based on a legalist reading of the laws divorced from their application. We have neglected to investigate with rigor what I consider two key components of property tenure and administration reforms. These are the introduction of a value-based property tax and the legally sanctioned persistence under the reform regime of pre-reform institutions and procedures for handling land matters, such as the Sharia courts. Expanding our methodology to more comprehensively study reform opens a door to substantially different conclusions about the nature of reform, its implementation, and its outcomes. What can these sources tell us? In 1895, Ismail Badawi al-Khamisi of Tafuq made a claim to the Sharia court in Hebron regarding farmlands in the Mezra of Jamrura. He told the presiding judge, Abdulqadir Effendi al-Hamouri, "Al-aradi muqayyada wa matuba." From his testimony, we can understand that, in the same way that Google became a verb as it became the preferred search engine at the turn of this century, likewise in rural Hebron, by the end of the 19th century, they were tapuing. There are two further elements to note regarding this court case. First, the land was not only tapued, it was registered muqayyida and tapued. Ismail was talking about two separate events, I suggest in the order of their importance: tax registration and following it, tapu. Secondly, his land case is being dealt with near the turn of the 20th century in the Sharia court. The continuance of this pre-reform practice has been observed by researchers to have occurred in a number of courtrooms, in Haifa, in Salt, and in Damascus, for example. An argument has been made that this is another sign of the failure of reform implementation. However, not only did the Sharia courts produce documents needed for tapu registration, reform law envisioned their continuing role in doing so. The late 1860 law on the registration of census and properties twice mentions, in Article 12 of Chapter 2 and in Article 3 of Chapter 6, that the Islamic law courts and the pious endowments of Kaf continue to have the power to renew title deeds needed for registration and to carry out property sales and transfers. The law stipulated only one precondition: that the new property tax had been paid. The team that surveyed Hebron in 1875 was thorough. It recorded each property's borders, its relative location by name, and the name or names of its owners. It estimated parcel sizes in the new measurement of dunam and registered structures according to the number of their roofs. It calculated the worth of each property and assigned to it the new value-based property tax, an annual imposition of 4 per mille. The results of this survey were recorded in likely 2 large registers, of which I have located one, this one. These draft registers were then combined into this 350-page reference register for the entire sub-district. The Defter Asas Imlak provides us a rich, panoramic view of the rural Palestinian socioeconomic landscape of the late 19th century: individual, family, village, intervillage, and urban-rural patterns of landholding and property, the distribution and administration of land and wealth, village composition, layout, and organization, and the expanse, type, and location of agricultural production. The register lists 3,647 residences and 233 other structures in Hebron's 50 villages, and about 500,000 dunams of farmed lands, registered to villagers, collectively to villages, to a small proportion of urban residents, and also to out-of-district owners from other villages in Palestine. Analysis of the line entries in the register and comparison of data with the other available indices: household counts in Ottoman yearbooks called Salname, the Ottoman total population registers of 1905 organized by households, and the next available village and district land survey data for the region, compiled at the end of the British Mandate, suggests that the 1875 register for rural Hebron is a reasonably reliable reflection of the situation on the ground and a testimony to the implementation of and large-scale compliance with this enormous project. In the village of Sa'ir, for example, whose lands you see here outlined in yellow surrounding the village of Shuyukh, villagers registered 10,714 dunams of agricultural land, the vast majority of it grain-growing land. As this chart shows, half of the property owners registered 30 or fewer dunams in total. A third of them registered between 50 and 100 dunams, and an elite stratum of 32 individuals, 16% of property owners in the village, registered 100 dunams or more in agricultural properties. The residence of the largest property owner, Isa Talja Idis, was the first to be registered among village structures. In terms of agriculture, the three indices available from over the past 130 years give us a measure of the development of agriculture in Zaire. They also serve as a relative indicator by which to evaluate 1875 registrations. While the figures for planted lands today in 1875 are roughly the same, it is clear that a shift in agricultural patterns from grains to trees has occurred. Moreover, today Zaire has 45,000 dunams of arable land, but the exploitation of all of it is economically unfeasible. According to the Applied Research Institute of Jerusalem, there is insufficient water supply on the one hand and a lack of capital to develop the lands on the other, rendering the village's agricultural sector today about the size it appears to have been in the late 19th century. In the Assas Imlaq Register of 1875, there is only one case of uncultivated, or perhaps unclaimed, farmlands in the district. This was at Sanabira, a mezra next to Khirbet Burj. The register noted that its 3,038 dunams consisted of 500 olive trees and fields suitable for grains. It had reverted to state property outright, with the notation in the ownership column, Mirimali Oldu. Next to it, at Burj, also a mezra at this time, 2,400 dunams of grain-growing lands were registered, farmed by villagers of nearby Nuba. Burj in subsequent years would develop into a settled village. In 1931, the village population was 119, according to mandate records. In 1945, the villagers were farming not 2,400 but 3,546 dunams of grain-growing lands. In 1949, the village was destroyed. Although the Assas Imlaq Register recorded all the information that one would expect to find in a tapu, title deed, cadastral survey, it was not drawn up for title deed purposes, but rather to implement the property tax. Late Ottoman financial figures show that the vergi, as this tax was referred to, became one of the highest four revenue generators in the empire. The new tax earned almost as much as customs duties into the 20th century, and generally more than the head tax on animals. We can understand from these figures that by the 1880s, indeed, a significant portion of this agrarian empire had complied with the innovation of a value-based property tax, registered their properties, and was paying 4/1000ths annually on land values. The vergi was an even more significant source of government income regionally in Palestine. In the Mutasarraf of Jerusalem in the fiscal year 1893-94, property tax revenues comprised 32% of provincial revenues, second only to the ushr on harvests, which accounted for 48%. In 1895 and 1897, the property tax earned slightly more revenue than the ushr. In other years, it was consistently the second highest single revenue source after this tithe. Although great emphasis has been placed on the question of the individualization of ownership and the privatization of property, in Palestine, as Martha Mundi has found in Ajlun, communal ownership was permitted, both for tax purposes and for titling. Additionally, property registers were not organized to facilitate a taxpayer's direct correspondence with the tax collector. Rather, taxes continued to be gathered at the village level. This we can understand when we try to trace an individual's property holdings. As illustration, we can examine the properties of the grandfather of the diarist Muhammad Abdul Hadi al-Sharuf of Nuba, whom we will hear about in Alex's presentation. Nuba provides illustration of three of the main types of registrations found across the Hebron district in 1875: individual, representative, and communal. Muhammad's grandfather, Muhammad Hassan Salem al-Sharuf, registered in Nuba, properties number 43, a residence, and property 89, one of 40 olive presses registered in the entire subdistrict. He also claimed 2 small garden plots located just outside the built-up area of the village, properties number 13 and number 131. The annual vergi tax on these 4 properties, imposed at the rate imposed uniformly across the Hebron district, 4 per meal, equaled 22 krush, about the price of a box of oranges at the Jaffa market at the turn of the 20th century, or a man's thawb there, or half the cost of a goat. Registered to Muhammad were also 2 sizable parcels of field crop land in the mezras of Wadi Sur and Burj, the latter of which we mentioned a few minutes ago. Wadi Sur was 1,673 dunams in size and farmed by villagers from 5 surrounding villages: Surif, Kharas, Nuba, Bet Ula, and Bet Natif. In all likelihood, Muhammad was not the actual landowner of the 441 dunams registered in his name in these 2 mezras. Rather, he had assumed the responsibility of gathering tax payments for his extended family's portion of these communal village lands. The comparison of registrations in the 2 mezras adds credence to this theory. We find not only the same 6 Nubawis registering property in both places, they are listed in the same order, and each has an approximately equal share of the lands. Aside from these properties, we can assume that Muhammad also had a stake in village lands registered communally: 2,225 olive trees and 5,633 dunams of field crop land registered to Haliyeh Mahsus, expressly for the people. Mathematically, this is 69 dunams and 27 olive trees for every residence in the village. Communal registration of grain land and olive trees can be characterized as a trend in Hebron at this time, as this table shows. This was not necessarily musha of these lands. Most of the villages registered at least some of their lands this way. All in all, about half the district's lands were registered in this manner. Just 6 villages chose to register every property to individuals: the large villages of Sa'ir and Bani Naim, and the small villages of Wadi Fukin, Artuf, Nahalin, and Jab'a. In Bani Naim, the list of properties ran to 1,549 entries, some of them 100 dunams or more in size. We know from early 20th century court cases and village histories that some of Hebron's villages registered their musha, as shown on this chart, without explicitly labeling it as musha. Other villages explicitly identified their communal properties in the registration as musha, in some cases as a 1-line entry, in others divided up among individuals in dunams, not in shares, but nonetheless labeled musha. There is still confusion in scholarly literature about whether the land code and subsequent reforms outlawed this prevalent form of communal ownership. This point is consequential because the continued existence of musha following reform, like the post-reform role of the Sharia courts in land matters, has been used as evidence to support assertions that Ottoman land reforms were resisted by the Falahin, evaded, and thus failed in Palestine. The subject of musha is a big one, and I can only mention it here. It will be treated in depth in the book I am now writing about Ottoman property tenure reforms in Palestine and their afterlives. Here I will offer just 3 brief comments, and with these I will close. First, as we have seen, the Ottomans permitted communal registration of lands for tax purposes. In my research, I have found this was also the case with the tapu. Second, as far as I've been able to ascertain, the debate over the legality of musha in the Ottoman period developed subsequently, during the Mandate, when there was a strong push to open up land markets which communal landholding inhibits and frustrates. Third, while the Tanzimat has most often been studied as top-down reforms, when we examine the implementation of property tenure and administration reform from the bottom up and broaden our methodology, a much more complex picture arises. The influential agency of ordinary landowners in the execution of these reforms begins to surface. The gradual grafting of reform into the fabric of society reveals a pattern pre-designed, and the economic factor as a motivation for reforms takes on greater weight. If this revised understanding of reform proves that we may put the hegemonic narrative to rest, the next step will be to ask larger questions that arise on both imperial and local levels, about the nature of the Tanzimat itself, and in Palestine, Israel, about the afterlives of this influential reform in historiography, and in mandate, Israeli and Palestinian law and policy.